Hello. This is the final episode in our podcast series about patent settlements and competition law, at least for now. I can foresee a sequel or a series of sequels as the various cases which are still in the court system proceed to judgment, and that will start with Lundbeck at the end of March. However, for the time being, I should say that the series has been intended to provide a good overview of the various issues that can affect the negotiation and drafting of patent settlement agreements from an EU competition law perspective, and to try and highlight some of the areas where the greatest risk can arise. As we've noted many times throughout the series, settlement agreements are a vital tool in the resolution of patent disputes. And although the content and form of a settlement agreement and the potential competition issues arising for it will necessarily depend on the nature of the settlement that underlies it, there are a few points of general relevance that it can't hurt for anyone who's engaged in those agreements to be aware of. And so for today's podcast, I'm delighted that I'm being joined by my colleague Erik Müürsepp, who's part of our commercial IP team at Bristow's. And he has wide experience of drafting settlement agreements in the pharma sector and finds himself talking to the competition team on a reasonably regular basis as a consequence, which he may or may not find to be a pleasurable experience. In any event, Erik is going to share with us some of his practical insights about the issues that he encounters on a day-to-day basis. So, Erik, from your experience, are there any common mistakes that you find the parties make which could inadvertently lead to issues from a competition law perspective?
Yeah, thanks, Pat. Well, we find it's often the case that once the litigating parties have agreed, at least in principle, to seek a settlement, there's then a lot of pressure to negotiate and finalize the settlement agreement as quickly as possible. And this may be, for example, because the case is on the cusp of a substantive hearing, or there are other commercial pressures to eliminate the uncertainty which is always posed by litigation. But whatever the underlying reason, experience has shown that it's always best, before putting pen to paper, so to say, to pause once the general outline of the proposed settlement is clear and reach out to competition lawyers, whether this be in-house or external counsel, and carry out an initial risk analysis of the proposed deal. It's much less effective to bring in competition experts to consider the settlement once the formal agreement is nearly finalized, because if it turns out that there are in fact some competition concerns, it will take time to renegotiate the commercial terms to mitigate that risk, and then to also reflect this in the drafting, which may then mean that the parties miss the deadline that they were actually working towards.
Interesting. And do you find that there are other times when it's helpful to advise the parties to take stock?
Yes, well, the course of negotiations itself can also be really variable, and the parties will often push to change the key terms, for example, by expanding or narrowing the scope of the settlement, or changing the date on which the generic may enter the market, if that forms part of the settlement. Now, any such material change may give rise to a competition issue where one just didn't exist beforehand. So it's always important to keep the competition lawyers in the loop during the negotiations beyond just the initial stage. And finally, it goes without saying, but competition laws vary from jurisdiction to jurisdiction. So for any settlement agreements which involve multiple key regions, it may be advisable, depending on the precise territorial scope, to take not only EU competition advice, but to also reach out, for example, to US antitrust counsel. Now, despite this common thread of timing pressures, the settlement agreements that we negotiate can actually vary quite a lot in terms of length and complexity, from, say, less than 10 pages to much, much longer and detailed agreements. Pat, I wonder whether this variability in any way affects how the competition authorities view the underlying settlement.
That's an interesting question. I think, generally speaking, length itself isn't a variable that troubles the competition authorities. But having said that, as a general rule of thumb, I would say that the simpler the final settlement agreement is, the less likely it is to give rise to competition concerns. That's a broad generalization, but If the parties simply agree to a pure walkaway from the litigation at hand, without including provisions relating to future market access for the generic or broad no challenge clauses, an agreement of that sort will rarely be problematic. It's typically only once there's a more complex set of rights and obligations that a risk arises that a restriction of competition will come out of the structure of the settlement itself or the specific terms when you read them in the round. Taking a closer look at the practical process, I'm interested to know when clients provide you with an outline for a proposed settlement, is there any aspect that you commonly see cropping up that flags a likely discussion with me or one of the other members of the competition team?
Yes, well, one feature that we see time and time again is a broadening of the scope of the settlement beyond just the patents that are the subject of the underlying litigation. So typically the originator and the generic will seek to ensure that not only is there a line drawn under the ongoing dispute, but also that further disputes will not erupt which involve equivalent patents of the originator and the same product of the generic, which will simply be sold in another jurisdiction. So settlement agreement of UK patent litigation may then end up encompassing the broader European patent family of the asserted patents, including national equivalents and divisionals, whether or not litigation has already commenced or been explicitly threatened in the other European countries. And this makes sense because the parties are keen to have the commercial certainty that accompanies a broad settlement, as the generic can then plan and prepare for a European-wide launch of its product, and the originator will know when the wider market will be subject to generic pricing pressures. As you might imagine, the savings in legal fees from avoiding a dispute in multiple national courts can also be very substantial. And occasionally we also find that the parties wish to have certainty as to the get-up or the trade dress that the generic can apply to its product once it launches on the market. Now, by get-up, we just mean the design or the labeling and packaging of the pharmaceutical product, which in the case of medicines delivered by way of a device like an inhaler, for example, that also extends to the design of the device. And it may be that the get-up that the generic intends to use is similar to the originator's current product get-up. So the parties may agree that the originator will not assert its rights to the existing get-up against the generic. And as with the wider patent families, this is just another instance in which the scope of the settlement is broadened beyond the actual IP rights in dispute. Pat, I think it'd be helpful to know how you go about assessing whether typical approaches such as these are problematic from a competition law perspective.
This is a particularly interesting aspect of patent settlements, and as you say, one that does come up all the time. Listeners may be surprised to hear, but in fact, the law is not particularly prescriptive on the question of how much broader a settlement agreement can be beyond the specific patents involved in court proceedings. Guidance from the Commission does indicate that the key question to ask is whether the proposed solution has a clear and reasonable commercial rationale that isn't likely to exacerbate competition problems. Now, in this particular context, it's quite clear, of course, that commercial parties will wish to seek certainty as to the future, and they certainly won't want to keep litigating the same issues in various jurisdictions. In essence, they perceive there to be a broad dispute which may touch on patent and other rights in various jurisdictions. So for them, the dispute extends beyond the litigation in one specific jurisdiction on one specific right, although litigation often crystallizes the parties' commercial positions. Given that background and that context, it is commercially rational to settle the overall dispute, and in most instances, settlements of this kind don't pose a material competition law risk, and in fact, may be pro-competitive because they give rise to considerable efficiencies. But as always in competition law, facts matter. And if a wide territorial or commercial scope could be perceived to potentially give rise to an anti-competitive market dividing arrangement, or to form some type of value transfer of the sort that I discussed with Ollie earlier in this podcast series, then the authorities will take a much keener interest in the settlement than in a simpler and narrower arrangement. And the parties will need to be able to explain the commercial rationale behind the scope, and also why any restrictions or prohibitions are necessary to achieve a sensible settlement of a bona fide dispute.
I think asking whether there's a commercial rationale for any provision is a really useful guiding principle, and it's in fact one that we also try to reflect in the drafting as much as possible. A great way to explain to the reader why the parties are entering into agreement is obviously to have really well drafted recitals at the beginning, but there's also much to be said for a clear drafting approach to the definitions and clauses, essentially making the settlement agreement read fluidly to a third party. Because at the end of the day, any instance of the reader of the settlement agreement having to ask, well, this particular provision doesn't seem to make sense within the overall scope of the settlement, is just another opportunity to raise suspicions, particularly if the reader is a representative of a competition authority. Perhaps it's worth mentioning as a final point that, as with any contract negotiation, there's much that gets recorded in writing beyond just the actual execution version of the settlement agreement. Both parties tend to prepare memos, exchange plenty of internal and external emails and issue lists, and prepare several drafts of the settlement agreement, all whilst their positions evolve over time, which is perfectly natural. I understand that the relevant authorities have considerable leeway in requesting copies of such documents if they suspect a breach of competition law has taken place, subject to sort of any applicable rules on privilege. I wonder if there's anything that the party should look out for when preparing these written materials.
That's a really good point, Erik. The parties and their advisors should always be aware of the potential for even innocuous statements to raise suspicions or concerns when they're read out of context. And while this shouldn't prevent a client from really freely exploring its options with its lawyers, the risks of being misunderstood should always be borne in mind. Both the European Commission and most national competition authorities have very broad evidence gathering powers, and it is incredibly important for parties to remember that the rules on privilege in particular can vary considerably from country to country. Taking as an example, privilege in competition investigations by the European Commission has quite a narrow scope. And in terms of who it attaches to, it doesn't extend to advice received from in-house counsel or from people who aren't qualified in a member state. The limitations to privilege, even in the context of settlement negotiations, means that care should really be taken to ensure that all communications and records, whether internal or external, are prepared carefully, bearing in mind the need to avoid the potential for unintended inferences. And if people are interested in understanding how internal documents can be used to build a case in the context of what's seen to be an anti-competitive settlement agreement, reading the CMA decision in the GSK paroxetine case is a very sobering experience.
Thank you, Pat. I think that's probably a really helpful point for probably all our listeners to be aware of.
Thanks, Erik. And for my part, I have to say it was really helpful for me to understand in a more sort of coherent way than just in the context of a quick chat in the office some of the issues that you and your colleagues encounter regularly when discussing these settlements with clients and other parties, and also how we can help parties achieve commercially acceptable and lower risk settlement agreements. So I do actually now look forward even more to the next time we work on one of these issues together. Having said that, I should also mention for the benefit of listeners that this episode of the series is accompanied by a short set of key takeaway points, and those can be found on the On the Pulse microsite. And we're always happy to discuss the practical application of those top 10 points with anyone who's thinking about the potential for a settlement. Thanks to everyone who's listened to the series, whether all the way through or just dropping in and out to podcasts of particular interest to them. In addition to the top 10 I've just mentioned, you can also find lots of additional content, including articles and webinars about issues of interest to those in the life sciences sector, both on the Pulse and also on the Bristow's competition blog, the Clipboard, where we often post commentaries on cases like paroxetine and Lundbeck. And speaking of Lundbeck, do check in on either on the Pulse or the Clipboard towards the end of March, when we will be posting our first reactions to the CJEU's judgment. Indeed, I do foresee the possibility for another podcast coming on. Until then, thanks for listening, and thanks particularly to everyone from Bristow's who's helped to make this series of podcasts possible, and such a lot of fun to be part of. Thank you.